Uh, Good afternoon, everyone present here. I am Manju Kundu, Assistant Professor, School of Education at Mangalam University. Would like to welcome you all on a sixth day of this one-week online interdisciplinary faculty development program on meaningful research and intellectual property rights, which is being held in a collaboration with the Faculty of Education, C.C.S University, Mir. On the sixth day of the session, the copyright violation and related rights will be the topic of discussion. Basically, copyright infringement is the use of the production of copyright protected material without the permission of the copyright holder. Copyright infringement uh, that the rights afforded to the copyright holder, such as the exclusive use of a work for a set period of time, are being breached by a third party. According to the World Intellectual Property Organization, copyright protects two types of the rights. Economic rights allow rights owners to derive financial reward from the use of their works by others. Moral rights allow authors and creators to take certain actions to preserve and protect their link with the work. Basically, the five fundamental rights that the bill gives to the copyright owners, like exclusive rights of reproduction, adoption, publication, performance, and display, are the stated generally in the section 106. It is a great pleasure for me to introduce our guest speaker, Dr. Baharul Islam, who is going to talk about the copyright violation and related rights. Dr. Baharul Islam has 15 years of teaching experience as a lecturer in a BRM Government College, Guwahati, Assam, assistant professor in the Center for Judicial Studies, Dibrugad University. He has also worked as an associate professor and head of the Department of Law, Apex Professional University, Pasigad, Arunachal Pradesh. Presently, he is working as an associate professor and dean University School of Law Research, University of Science and Technology, Meghalaya. He is completed BSA LLB from ILS Law College, Pune, and LLM with the specialization is in a business law from the Bharati Vidyapit University, Pune, Maharashtra. He qualified the UGC NET in the subject of law. He completed the PhD from Faculty of Law, Guwahati University. His broad research area was a judicial study of freedom of trade, commerce, and intercourse under the Constitution of India, with the object of removing economic imbalance. Presently, he is supervisor of six numbers of PhD research scholars. He has attended and presented research papers in various international and national seminars, conferences, and his publication in international and national journals. He participated in various programs as a resource person. He is actively associated with the various social activities and also members of many social institutions. We welcome you, sir, in the FDP on the sixth day of session. Before we proceed further, I would like to request Professor Dr. Tanya Gupta, Dean School of Education, to enlighten our participants with a few words. Tanya, ma'am.
Thank you, dear Manju ma'am. Good afternoon. At the outset, we welcome Dr. Baharul Islam ji, who is the Dean at the University of Science and Technology, Meghalaya. Sir, welcome virtually to our university, Mangalam University, and the School of Education especially. And we are very happy to have you and host you here on day 6 of our faculty development program, which has been organized in collaboration with Faculty of Education, C.C.S University, Meerut. And we are doing this on a very pertinent theme. As you know, it's meaningful research and intellectual property rights. And today being day 6, we, the participants have engaged through 5 days with wonderful speakers. And, they have moved from basics of IPR. Yesterday, we had a session on copyright. It was taken by Dr. Parikshit Sirohiji, and we also had session on patents. So I think the participants by and now have an understanding of what is meaningful research and intellectual property rights, And in IPR, they have had an understanding of patent, copyright and trademark. Today is a very important session which you are taking on. What if somebody violates the copyright and the IPR? It's a very important session, sir. We welcome you. We are so happy to have you. And before the session started, as we were interacting, we will look forward to have you someday with us at our university in Haryana. You are in Meghalaya, but we will be more than happy to have your university and you especially sometime there with us. So welcome, sir. Welcome on behalf of the
Thank you, madam. Thank you.
The entire organizing team, our patrons for this FDP, our Vice Chancellor of K.R. Mangalam University, Professor Dr. C.S. Dubeji. And also I'd like to welcome you on behalf of the Vice Chancellor of C.C.S University, Meerut, Professor Dr. Sangeeta Shukla ji, and our co-patron for this FDP, Professor Dr. Pushpalata Tripathi, who is the Pro-Vice Chancellor at our university. And on behalf of all of us who are there as an organizing team with you, we welcome you, sir, once again. And we are very keen to hear your session on such an important topic on copyright violation. So over to you, sir, and welcome.
Thank you so much, Professor Dr. Tanya Gupta, ma'am. Thank you. Thank you so much, Coordinator Ms. Manju Kundu, ma'am. Thank you so much, Dr. Anshul Seluza, ma'am. First of all, I'd like to extend a heartfelt thanks and gratitude to the School of Education, K.R. Mangalam University, and Faculty of Education, C.C.S University, for giving me an opportunity to deliver one talk, especially interact with the participants of 1 week in interdisciplinary faculty development program organized jointly by School of Education and Faculty of Education of 2 university. So first of all, I'd like to take a few seconds for sharing my PPT. Is it visible, ma'am?
Yes, sir,
Yes,
it's
visible.
Okay, thank you so much. Dear participants, because of formality, I am this side, otherwise could have been better to that side. So let's start one of the important topic of discussion for today, that is copyright violation and related rights. Before starting this topic, I would like to share my thought and few points regarding the intellectual property, especially for participants. So intellectual property always been an outcome of use, effort, use, expenditure of money, human resource involvement, and dream and desire of few people, and it is nothing but a property which is created by human intellect only. But nowadays there is another invention which is called as artificial intelligence. So till date there is a dispute that whether the artificial intelligence should be given the status of personality or not. But recently, just 1 month back, in the country of Australia and South Africa, they recognized that artificial intelligence is also person, just like human being, means personality status assigned to the corporate and society is also assigned to the artificial intelligence. So artificial intelligence itself is created by the human being. So personality is assigned. So intellectual property may be created by those artificial intelligence also. So exclusive right to the intellectual property holder means for exploitation or exploration of intellectual property, that also could be given to the artificial intelligence, that is emerging issues in case of intellectual property. So in case of ethics is concerned, exploration is concerned, financial benefit is concerned. So lots of issues and challenges would come, and that could be settled down by the respective government, and especially in India, there is no categorical rules in this regard, but hopefully within very short period of time, the parliament will take initiatives for the recognitions of artificial intelligence and the intellectual property created by an artificial intelligence too. So that is all about the new challenges in case of intellectual property is concerned. So come to the copyright. So copyright is also one of the intellectual property, just like a patent, trademark, industrial design, geographical indication, and all that. But in case of what is the unique feature of copyright is concerned, in case of patent, the owner will get only 20 years period of time for exploration or exploitation of a patent. But in case of trademark, industrial design, and all that, they get only 10 years. But it is the copyright is one of the exceptional intellectual property, because in this intellectual property, the term period for complete exploitation is given a whole life of the author plus 60 years. So that is why it is one of the exceptional and one of the great kind of intellectual property which is generally assigned to the author. So copyright is also a kind of intellectual property. Importance of copyright is increased due to the repeat technological development in the field of printing, music, communication, entertainment, and education, and computer industries. So in case of development of technology is concerned, new challenges come before the court, or even become part of the educational or academic discussion, because new types of infringement arise, new types of copyright arise, then new types of questions and issues arise that copyrights in case of new things which can be included as a part of copyright or not. So in the day by day, due to the technological development, challenges and opportunities also come in case of copyright is concerned. So I'm going to just give a brief introduction and brief discussion on basics of copyright, so that we can understand easily in case of violation and other related rights is concerned. So as far as definition of copyright is concerned, we have a legislation, that is Copyright Act 1957, which does not clearly define what is copyright, but just which includes certain rights, just like original, literary, dramatic, musical, and artistic work, and cinematograph films and sound recordings. So literary includes a computer program also. So it is nothing but a right, exclusive right given to the persons who have done something in this field, means literary, dramatic, musical, and artistic work, cinematograph, films, and sound recording, means who have make effort, who have labor, expend money, engaged human resource, and there is a certain outcomes which is original, in which the exclusive right given to the author to explore it, to exploit it, and to get the financial benefit either by exploiting himself or make assignment or license to the others. So that is all about the definition is concerned. Then what copyright generally protects? Copyright does not protect the idea. Even its idea does not protect in case of patent also, or in case of trademark and other, because unless and until the idea is expressed and work on it, make effort, labor, money if required, then what will be the outcomes? If it is original, then that will be protected as an copyright, otherwise not. So there is no copyright in ideas. Copyright subsists only in the material form in which the ideas are expressed. What copyright protects is not the raw materials from which the work is created, but the skill and labor employed by the author in the creation of that work. So as far as the object of copyright is concerned, the object of the copyright law is to encourage the authors. Of course, unless and until there is a suitable provisions of law or society to get certain benefits out of a particular work, then nobody will be interested to that. Or only few people may have, they have different types of people, different types of mentality. They are artistic, or definitely they will do that types of work. Otherwise, if it is not protected as a property, because intellectual property is also a property, just like other property, it is incorporated. So if it is not protected, then the others peoples may not have interest to do such type of work. So that is why that is the main reasons for the protection of copyright is concerned. So the object of the copyright is to encourage authors, composers, artists, designers to create original works by rewarding them with the exclusive right for a limited period to exploit the work for monetary gain. The economic exploitation is done by licensing, such as exclusive right to entrepreneur like publishers, film producers, and record manufacturer for a monetary consideration. People generally who economically exploit the copyright are the greater beneficiaries of the copyright law than the creator of the work of copyright. It is true because suppose the artistic work, one books is written by an author, but he doesn't have the publishing authority, because in case of having a publisher, there are so many formalities needs to be fulfilled to become a publisher, authorized publisher or recognized publisher. And publisher is nothing but a trade. He needs trade license, and lots of formalities needs to be done in case of state government is concerned, including GST. So the artistic people generally doesn't have the business knowledge, business transaction, and they may not be involved themselves in business. So generally their artistic work assigned to the others for economic exploitation. And maximum benefit in case of copyright is concerned get by the people who are doing business on copyright. Suppose just like one song written by a person, so definitely he's, or song or poetry written by a person, so definitely he's going to give a person who is going to compose, then definitely he is going to license to the producer. Ultimately, suppose one person's making a film, there are lots of copyrights may be involved. Just like in case of actor actress is concerned, they will get the performance right. In case of story who has written, he may get the copyright. Then in case of the songs who has written, he will get the copyright. The song who composed, he may get the copyright. So in case of every kinds of copyright, that should be, or generally in practice, ought to be licensed or assigned to the ultimately the producer of the film. So ultimate beneficiary would be the producer of the film. So similar things happened in case of other kinds of copyrights also. So the basic objective is the protection of the right, who make the effort for creating something which is new in the field of literary, dramatic, artistic, musical, cinematography, film, computer, software, and computer database, and sound recording, etc. So copyright and technology, we have already discussed that nowadays technological development, technological progress has made reproduction of copyright material easy and cheap. But at the same time, it has made piracy of copyright work simple and difficult to control. As far as international copyright law is concerned, we have numbers of conventions and we have numbers of institutions who generally directly and indirectly involved in case of protection of intellectual property as well as protection of copyright. So at international level, the copyright are protected under conventions such as WTO agreement, the implementation of TRIPS. In case of patent regime was the primary requirement in order to enable participations in multilateral trading system. So copyright of nationals countries which are members of the Berne Convention 1886, Universal Copyright Convention 1952, TRIPS Agreement in 1994, Rome Convention 1999. Another important thing I want to say that intellectual property, especially the copyrights, is one of the vulnerable property which may be exploited very easily, which may be moved from one country to another country very easily, which may be pirated very easily, which may be infringed very easily, because the access to intellectual property nowadays, because of development of technology, is very easy. So suppose the national law cannot protect the intellectual property in complete sense because it may be exploited or it may be infringed or it may be pirated in neighboring countries or any countries of the world. So very easily. That is why it is called as one kind of vulnerable, one kind of very weak in case of protection is concerned, in case of vulnerability is concerned. So that is why international framework, one types of international uniform framework for the protection of intellectual property, especially the copyright, is essential. That is why these are the conventions and these are the organizations we have which is generally directly involved in case of protection of intellectual property. And India, in both the Berne Convention and Universal Copyright Conventions, India is a member. So India protects not only the copyrights which is produced in India, but also which are produced in other countries, because we have a mechanism that we cannot allow the copyrights which is created in foreign country, which author belongs to the foreign country. So we cannot allow Indian people also to pirate those intellectual property, because intellectual property or creation of intellectual property requires huge effort, so that it should not be exploited by piracy or infringement. So these are the organizations or conventions which generally protect the intellectual property, especially the copyright, globally. And there is a WIPO Copyright Treaty 1996. This treaty specifies that protection extends to expression and not to ideas, procedures, and method of operation or mathematical concept. The treaty recognized the computer programs as literary work. So WIPO performs at Phonograms Treaty 1996 declares that the protection of performers and producers of phonograms. So these are the organizations and institutions and the conventions which generally protect intellectual property in general, but we have a copyright Universal Copyright Convention also for which is specific for the protection of the copyright. So as far as copyright law in India is concerned, we have a Copyright Act in 1957, came into force from January 1958. The Copyright Act has been amended in 1983, 1984, 92, 94, 99, and 2012. The Copyright Act 1957 generally consists of 97 sections, fewer than 15 chapters, while the Copyright Rules 1958 consist of 28 rules under 9 chapters and 2 schedules. So in case of every parent act which needs certain rules, because in case of parent act delegates certain powers to the central government to make rules for implementation of that act. So we have a Copyright Rules 1958. The landmark amendment in copyright is copyright in 1994, which is related to computer software. According to section 14 of this act, making and distribution of copyright software without proper and specific permission is illegal. Means it becomes one of the criminal offense in case of piracy of computer software is concerned. So these are the main features of copyright. It is one of the monopoly right given to the authors for exploration, for publications, for earning money, and it is not a single right, it is multiple right, because in case of copyright is not a single right, it consists of bundle of different right. The bundle right includes right of adaptation, means suppose from drama, from novel to drama, from drama to cinema. So a series of work can be done by the author. Then right of reproduction, then right of publication, right to make translation, communication to public. These are the basic rights. Not limited to this. There are other rights can be exercised by the author, and it is called as negative right. Why it is called as negative right? Because it restricts the others. It restricts the others not to interfere, not to make infringement, not to copying it, not to pirate it, not to violate the rights of the author. So that is why it is called as one of the negative rights in case of protection of copyright is concerned. So copyright can be assigned to anybody. There is a transfer and transmission, both applied in case of copyright. Transfer means transfer between two intervivors. It can be sale, it can be leased, it can be do anything. And transmission is which is generally operated by law after death of the person. So then it is regulated by the law. Regulated by the law means the legal heirs can get the copyright, or if any will made by the author, then that will be operated by the law. Then license also can be assigned to in favor of other persons, but license can be complete exploitation of the copyright, or limited rights can be assigned to the other persons also. So as far as assignment is concerned, it can be transfer, it can be transmission, it can be license. So this, because copyright is also a property, so whatever can be done in case of other property is concerned, that also can be done in case of copyright in liberal sense is concerned. So relinquishment of right, copyright is of course is a legal right, so it can be released by anybody. It is not a fundamental right, so in case of fundamental rights nobody can relinquish, but it is a property right, so it can be relinquished by giving one notice to the registrar of the copyright only. So as far term of the copyright is concerned, that is very unique in case of literary, dramatic, musical and artistic works, where the author is a natural person. The term is lifetime plus 60 years. That is why it is unique, because it is the highest period of time in compare with the other intellectual property is concerned. But the period of copyright for a photograph, cinematograph, films and sound recording shall subsist up to, until 60 years from the beginning of the calendar year. But if it is copyright created by not by natural persons but a juristic person, because companies, if registered under the Companies Act 2013, it's become a juristic person. So if the owner of the copyright is a juristic person, then the term of the copyright is 60 years from the date of registration. So now come to the main topic, that is infringement of copyright. So piracy of the copyright, that is generally violation of the right of the others. So copyright is a right, is a legal right. It is generally protected internationally as well as nationally by different laws. In case of international, there are lots of organizations and conventions we have discussed. But in case of national, we have a concrete and codified law passed by the Parliament of India in 1957 that is generally make the protection of the right of the author. So in case of any infringement, in case of any violation, in case of any theft to the copyright, so there is a sanction, and sanction in the form of civil, criminal, as well as administrative. So in case of infringement is nothing but a violation of right of the author. The owner of a copyright work has the exclusive right to do certain acts in respect of the work. If any person does any of this act without authority, he will be committed an infringement of the copyright in the work. However, the copyright work can be used for certain specific purposes without committing an infringement. Means there are certain exceptions also provided under the Copyright Act 1957, in which the other can do certain limited things even without the license, without the authority, without the consent from the owner. But that should be fair. We are going to discuss later on. That should be fair. That should not be in commercial exploitation. That should be personal. That should be private, and that should be done with good faith. And that should be either for the purpose of research or in case of academic deliberation, academic discussion, or a domestic purpose. So certain exceptions are also there. If the infringement fall under any exceptions, then that should not be treated as infringement. And the infringer should not be punished as per Copyright Act 1957 is concerned. So in case of infringement of copyright, there are three types of remedies available against infringement of copyright, namely civil, criminal, and administrative. So in case of civil, there is a provisions of injunction. We'll discuss later on regarding the remedies in case of infringement of copyright is concerned. So as far as definition of infringement is concerned, copyright in any work is deemed to be infringed. Number one, when any person without a license from the owner of the copyright or the registrar of copyright, or in contravention of the conditions of a license granted, or any conditions imposed by a competent authority under the Act, or does anything the exclusive right to do which is conferred upon the owner of the right. Means whatever can be done by the owner of the right, if done by any other person without consent, without authority, then that should be treated as infringement of copyright. Or permits for profit any place to be used for the communication of the work to the public, where such communications constitute an infringement of the copyright in the work, unless he was not aware and had no reasonable ground for believing that such communication to the public would be an infringement of copyright. Just like suppose one pirated copy of any particular movie, if it is shown in any particular place, the owner of that particular place is also involved in the offense of infringement of copyright. So if he done honestly without knowing that it is a pirated copy, and then he may be get the or fall under exceptions. So as far as number two is concerned, where a person makes for sale or hire, or sells or lets for hire, means it is nothing but just tense is concerned, or by way of trade displays or offers for sale or hire any infringing copies of the work, that will be treated as infringement of copyright. Number two, distributes either for the purpose of trade or to such an extent as to affect prejudicially the owner of the copyright any infringing copies of the work. Number three, exhibits to public by way of trade any infringing copies of the work. Number four, imports into India any infringing copy of the work, except one copy of any work for the private and domestic use of the importer. Means in case of importing from the other countries, any pirated or infringed copy of copy in which copyright subsists. So in case of any one copy for private use, so that shall not be treated as infringement. Means private use can be done by any individual, even though whether the work is Indian or even it is in foreign country. So the reproduction of literary, dramatic, musical or artistic work in the form of cinematograph film will be deemed to be an infringing copy. In a general, it is commercial exploitation of the work in any form by a persons without authority that constitute generally infringement. So first of all, we have to understand another important thing. So what is infringing copy? Infringing copy means in relation to literary, dramatic, musical or artistic works, a reproduction thereof otherwise than in the form of a cinematograph film. So reproduction of books written by one person, which is copied by the other person, just like published it, that is called reproduction of a book. There is one very important case. One book is generally translated from French to English, which is not pirated, which is with the due approval, and from another person from English to he translate the books from English to French again. Means original books is in a French language. So one with the due process translated into in English, then another person without due process he translated from English to French. So in French language, both the copies found same, identical and similar. So the third persons who have committed the infringement generally is a guilty person, and that is also treated as infringement of copyright. So in relation to cinematograph film, a copy of the film made on any medium by any means. Number 3, in relation to a sound recording, any such recording embodying the same sound recording made by any means. So in case of sound recording, there needs to be a detailed discussion but paucity of time, we cannot make it. In case of sound recording, the one person's composed something or recorded something, whether it is natural or whether with the help of any other instrument. So in case of suppose the other person just added something without approval or without getting the license from the true owner, then that can be treated as infringing copy of sound recording. So in relation to a program in which a broadcast reproduction right subsists under section 37, a sound recording of the program. The import of one copy of any work for the private and domestic use of the importer is permitted. We have that is well-known fact. In case of domestic and personal use, then any one copy you may have, even though it is imported, then that should not be treated as infringing copy. So what are the essential ingredients of infringement? So depending upon the kind of copyright work, because there is not a single work in which the copyright subsists, there are lots of work in which the copyright subsists or in which the author can claim the copyright. So as far as kind of copyright work is concerned, infringement involve one or more of the following acts. Number 1 is reproduction of the work in a material form, whether it is a film, if it is reproduct, whether it is artistic work, if it is reproduct, whether it is literary work, if it is reproduct, whether it is a computer program, and if it is reproduct, without making any effort, without any creative effort, and without any genuinity, so that will be generally treated as infringement. Then publication of the work, of course, the infringing copy, if it is published by the infringer. Then communication of the work to the public, if it is suppose pirated copy of a cinema and which is shown to the public, and shown to the public, not because of only entertainment, but because of also gaining any profit, commission, or whatever may be. So means commercial or trade purpose, then performance of the work in public without getting the license or approval or consent from the author, performing the work in public. Number 5 is making of adaptations and translations of the work, and doing any of the above acts in relation to a substantial part of the work. These are the essentials in case of infringement of copyright is concerned. So there are certain exceptions in which we may have a copy, in which we may have used the copy in which the copyright subsists, but that should not be treated as an infringement or piracy. So as far as the Copyright Act is concerned, it provides certain exceptions to infringement. The object of these exceptions is to enable the reproduction of the work for certain public purposes, for encouragement of private study and research and promotion of education. They provide defenses in an action for infringement of copyright. So in case of research, suppose one book authored by Mr. X, which is not available in the market. So in case of any research institution, in case of any educational institution, can make of 3 copies of that book. They may keep in a library. That is for reading purpose, that is for research purpose, and that should not be treated as infringement of copyright, even though without the permission from the owner, because that should be treated as fair dealings, and that should not be treated as an offense because it falls under exceptions, and which is exclusively for the purpose of research, which is exclusively for the purpose of academic, and which is for the benefit of the students or faculty members. So as far next is as far as section 52 gives a long list of acts which do not constitute infringement of copyright. They are briefly stated as follows. Number 1, a fair dealings with any work for the purpose of private or personal use, including research, criticism, review, making copies of computer program for certain purposes, reporting of current events and current affairs, including the reporting of a lecture delivered in public. So these are the activities, if done by anybody, that will be treated as fair dealings, and that should not be treated as infringement of copyright. So in before discussing the other points of other points which are generally fall under exceptions to the infringement of copyright, I'd like to mention here that if any persons who on good faith dealings with any artistic, musical, sound recording, computer software, cinematograph, film, in good faith, and which is not for commercial purpose, and there is no guilty mind, there is no plan, different types of plan for exploitation of the author, so that will fall under exceptions, and that should not be treated as infringement of copyright, because in case of domestic, in case of educational purpose, in case of research, in case of criticism, suppose in case of judgment passed by different high court and supreme court, that can be recorded in good faith, unless and until the judges delivering the judgment make the restriction that this judgment shall not be published by anybody unless and until consent taken from the respective court, then that should be published. So in with honesty, with good faith, anybody can, and which is not generally commercial purpose, then anybody can do anything in case of copyright is concerned. So number 2, reproduction for judicial proceedings and reports thereof, reproduction exclusively for the use of members of legislature, reproduction artistic work excluded in a certified copy made supplied in accordance with law. So I have already discussed that in case of judgment passed by the Honorable Supreme Court, High Court, or any subordinate court, that can be compiled by anybody and that can be published, even though the judgment passed by the Supreme Court and High Court are different. Suppose AIR means All India Reporter, Supreme Court cases, then different High Court or different state, they have a different types of journal. So they copied the judgment passed by the respective court, and that is, even though it is done for commercial purpose, but that is not treated as an infringement of copyright. So reading, recitation in public extract, literary or dramatic work, I am also doing here the same things because I have prepared this PPT from different books or even from internet sources, but this PPT shall not be treated as infringement of copyright because I am doing it because of academic purpose. So even though if I say the quotation of any judges, quotation of any jurist, quotation of any persons, even though that shall not be treated as an infringement of copyright because the purpose and motive is fair enough and it fall under exceptions that it is we are doing because of academic deliberation and academic activities. Then publication in collection for the use of educational institution in certain circumstances. We have already discussed the reproduction of teacher and pupil in case of course, instructions, or in question papers. So we can prepare the syllabus from referring any books or content of any books that shall not be treated as an infringement of copyright. We teach the student from any book that shall not be treated as an infringement of copyright. We prepare different notes. We prepare different PPT, deliver the students, copied from books that shall not be treated generally infringement of copyright because that is completely based on educational purpose. And question paper set from any particular books or even the question answers also prepared by the teachers and delivered to the student, that also shall not be treated as an infringement of copyright. Number 6, performance in the course of activities of educational institution in certain circumstances. Generally in educational institution, we organize different cultural events, or we generally listening different music through loudspeaker. We show different types of art, documentary, or even commercial movie for review of the students. So that should not be treated as infringement of copyright. That is because completely based on educational purpose and non-commercial act. Number 7, the making of sound recording under certain circumstances subject to certain conditions. We have only one day we're going to celebrate Independence 75th Independence Day. So on that day we're going to have different songs. That is, the composer is different, producer is different. That is also copyright is subsist, and they have an author, but without authorized letter, without consent from the author, we're going to play or we're going to listen the music. So that should not be treated as an infringement of copyright because of two factors. That is, that shall be treated as a domestic. Number 2, that should not be used for commercial purpose. So number 8, the causing of sound recording to be heard in public by utilizing it in an enclosed room or in clubs in certain circumstances. So that will also fall under exceptions to the concept of infringement of copyright. So performance in a amateur club given to a non-paying audience or for religious institutions, that is also fall under exceptions. So reproduction in newspaper and magazines of any article on current economic, political, social and religious topics in certain circumstances. These are act, and these are act fall under the exceptions, and these are not for the not infringement of copyright. So publication in newspaper and magazines, a report of lecture delivered in public. So if any persons delivered in a publicly any lectures which is generally reported in newspaper or magazines, that also not to be treated as an infringement of copyright. Making a maximum 3 copies for the use of public library, that is also fall under exceptions. Then reproduction of unpublished or kept in a museum or library for the purpose of study or research, that is also fall under exceptions. So reproduction or publication of any matter published in official gazette or reports of government commission or other bodies appointed by the government, means this can be done, no infringement of copyright. Reproduction of any judgment or order of court, tribunal or other judicial authority, not prohibited from publications. Number 16, production or publication of translation of acts of legislature or rules. Excuse me. So number 16, publication, production or publication of translation of acts of legislature or rules, acts passed by the Parliament of India or state legislature that can be translated to any language, and that should not be treated as a infringement of copyright. Making or publishing of any painting, drawing or photographs of work of architecture. The number 18, making or publishing of a painting, drawings or photographs or other artistic work permanently situated in a public place. So whatever the painting, drawings, photographs or artistic work which are generally permanently situated in a public place, that can be published, that can be paint again, that can be draw again, the photograph can be taken, that can be commercially used by anybody, that should not be fall under in the category of infringement of copyright. Number 19, inclusion in a cinematograph film of any artistic work permanently situated in a public place and other artistic work by way of a background or incidental to the principal matter representative in the film. In respect of computer program, the following acts do not constitute infringement. So that is all about the infringement of copyright, and there are certain exceptions. But in case of based on the category of the copyright is concerned, the act which generally infringe that category of copyright we can discuss here. So in case of infringement of literary, dramatic or musical work, if a person without the consent or license of the owner of the copyright does or authorize the doing of any of the following acts, he will be guilty of infringement of copyright in the work. Number 1, to reproduce the work in any material form, including the storing of it in any medium by electronic means. Storing means whether it is physical, just like books, novels, journals, or in case of soft copy is concerned. So in case of storing, reproductions, all shall be treated as infringement of copyright. So to issue copies of work to the public, not being copies already in circulation, so make copy of any journal, to make any copy of computer software, to make a copy of any dramatic work or musical work, and which make available to the public or make circulations for commercial purpose or not even non-commercial purpose, that shall be treated as infringement of literary, dramatic, or musical work. To perform the work in public or communicating it to the public, generally the performer they have a right, they have also the copyright, but if they perform the work of the other, they must get the consent of the other. Number 4, to make any cinematograph, film, or sound recording in respect of the work. Number 5, to make any translation of the work. Number 6, to make any adaptation of the work. Number 7, to permit for profit any place to be used for the communication of the work, just like cinema hall and all that, for commercial purpose. Number 8, to make infringing copies of the work for sale, for hire, or sales or lets for hire or display, or offers for sale or hire infringing copies. Or number 9, to distribute infringing copies either for the purpose of trade or to such an extent as to affect prejudicially the owner of the copyright. Number 10 is to exhibit infringing copies by way of trade to the public, just like painting of M.F. Hussain without the consent. So nobody can exhibit it any place for commercial purpose. Or Manju madam, is it okay? Can I continue?
Yeah, let's continue, sir.
Yeah, okay, thank you, ma'am.
Yeah,
so number 11 is concerned to import into India infringing copies. However, the import means we have already discussed that importation can be made just like one copy for domestic use only. Otherwise, that should be treated as infringement of copyright. Number 12, in respect of computer program, which is a form of literary work, to do any of the acts specified above, means whatever the act we have already discussed in case of literary and dramatic work, that will be applied in case of computer software also. To sell or give on hire or offer for sale or hire any copy of the computer program, regardless of whether such copy has been sold, given on hire, or earlier occasions. So, but it has also certain exceptions in case of specific infringement of literary, dramatic, and musical work. The following are the exceptions. Definitely, the first one is fair dealings that will be applied in case of application of intellectual property, specifically the copyright. If it is fair dealings without any guilty mind, without done for profit or commercial purpose, then that shall not be treated as infringement of copyright. Number 2 is reproduction. Reproduction of a part or whole of the work is permitted for the following purposes. Means these are the following purposes in which reproduction is permitted: in judicial proceedings or in a report thereof. Now, next, for the exclusive use of the members of a legislature, state or central government, the state and central government has that exclusive privileges. In fact, they may have the copy from any sources for placing it before parliament discussion or legislative assembly discussion. So that shall not be generally treated as infringement of copyright. So in a certified copy made or supplied in accordance with any law, that is artistic work excluded, means with the permission of the author, then they can do anything what the author can do so and that shall not be treated as infringement of artistic, literary, artistic and dramatic work. For teaching and examination purpose, we have already discussed. So we can use any books, any art journals. You can any journals of any author in India or even abroad. We can prepare notes. We can deliver to the students. We can prepare the questions paper from the books, journals, or any copyright, any work in which the copyright subsists. So that shall not be treated as infringement of copyright. So for use in newspaper, magazines, periodicals of any article of current economic, political, social and religious topics, unless the author has expressly reserved the right to himself. So in such situations can be done. For use of public libraries, not more than 3 copies where the work is not available in India. Reproduction of an unpublished work kept in a library subject to certain conditions. Next, reproduction of publication of certain government publications. Any matter published in any official gazette except acts of legislature. Then acts of legislature accompanied by the commentaries. Report of committees appointed by government if there is no prohibition. Means any report passed by the passed by any government, any special committee appointed by the government, any commission appointed by the government. So any data from that report can be copied, can be published, and that will fall under exceptions. But if in the report it is restricted by the concerned authority, concerned commission or the government that it should not be published, it should not be used, it should not be copied, then that cannot be done by anybody. So judgment or orders of any judicial authorities unless prohibited. Number 5, production or publication of any translation of acts of legislature if such legislation have not already been published or not available. So in case of any act of parliament or state legislature that can be published, that can be translated, that can make own comments and then published. Then publication in newspaper or magazines of any report of lecture delivered in any public. So as far performance is concerned, performance of a work or a film or record by the staff of educational institutions subject to certain conditions, or performance of the work by amateur club or society before or non-paying audience or for the benefit of religious institution does not constitute infringement. So these are normal things we are used to do, and it is not infringement of any copyright. As far as sound recording is concerned, making of sound recording in respect of work is permitted under certain circumstances on payment of royalty only, and playing of sound recording in residential premises or in a club not for profit is also permitted. So in case of infringement of copyright, these are the circumstances in which the copyright may be infringed, just like reproducing the work in any material form, including the depiction in 3 dimensions of a 2-dimensional work, or in 2 dimensions of a 3-dimensional work, communicating the work to the public, issuing copies of the work to the public, not being copies already in circulation, or making for sale, hire, or selling or letting for hire, offering for sale, etc., infringing copies of the work. That is, we're talking about the artistic work. Distributing, exhibiting in public for trade, infringing copies of the work. Importing, infringing copies of the work except 1 copy for private use. But it has also certain exceptions, that is just fair dealings in case of artistic work. So in case of any fair dealings without intention to harm the author, without intention to infringe the copy, but which is for the welfare of the society, for the personal use of the infringer or domestic use for the infringer, that can be done in case of artistic or also, and that can be reproduced on justified ground. Justified ground, whatever the justified ground we have discussed in case of in general infringement or exceptions of general infringement of copyright is concerned. In those justified ground, it can be infringed, but that shall not be treated as infringed. Means that can be copied and used, but that is not a civil as well as criminal wrong. Now, in case of infringement of cinematograph film is concerned, following are the acts in which the cinematograph film shall be treated as an infringement: to make a copy of film, including photograph of any image forming part thereof, to sell or give on hire or offer for sale or hire any copy of the film, regardless of whether such copy has been sold or given on hire or on earlier occasions, to communicate the film to the public. So nowadays, when a film is released on Friday, just after finishing the first show of the film, the pirates generally pirates the film and make it available in different websites, and lots of people are downloading that film from those websites and see. So that is happening in India is concerned. There are lots of pirated videos. There are lots of pirated cinemas. There are lots of pirated different types of artistic work which are involved in cinematography is concerned. That is going on, but very limited people who are very concerned with concerned in case of infringement of copyright in case of cinematograph film is concerned. So these are also includes in case of infringement of cinematograph film, to permit for profit any place to be used for the communications. Generally, in case of pirated cinema is concerned, if it is used in any particular place, that also to be treated as an infringement of cinematograph film. But nowadays it is available. Everybody have access to those pirated cinema, pirated video. They download or online they can see it through laptop or mobile or any other devices. Nowadays it is happening everywhere. So it is that is why I am always talking about that it is intellectual property is one of the vulnerable and weak property which can be infringed, which can be pirated, which can be violated from anywhere of the world, and nobody will care, nobody notice it, nobody brings to law, nobody take the law into motion, and nobody take the cognizance in case of such type of violation is concerned. So to make any infringing copy of the film for sale or hire, it is may not be happen nowadays, I think so, because everybody have access to the pirated copy from different websites. So number 6 is to distribute infringing copies either for the purpose of trade or to such an extent as to affect prejudicially the owner of the copyright. It is happening a few years back when there was no internet. There was only in case of film is concerned, there was one cassette which is that there was an original cassette, and the people's make pirated cassette and commercially explode. But nowadays it is not it may not have the relevant that much, because nowadays internet and pirated cinemas are available to everybody. They can be downloaded from any site. The next is to exhibit infringing copies in public by way of trade. So that is also not relevant today, because everybody, nobody will see the pirated video by paying fee, because everybody has access to pirated video. Number 8 is to import into India any infringing copies of the work. In case of cinematograph film is concerned, there is no requirement to import anything, because first there was a cassette, then second, then pen drive. Nowadays, pen drive is also not required, because it can be sent. Anybody can send from USA to me just within few seconds any movie, any cinematograph film. So importations due process is also not relevant in today's scenario is concerned. So in case of infringement of copyright in sound recording is concerned, following are the acts which are also similar in case of cinematograph film, which are also similar with the in case of artistic and dramatic work is concerned. Number 1, to make any other sound recording, embodying it to sell, given hire, that is also similar with cinematograph film is concerned. Number 3, to communicate, that is also similar with the cinematograph film is concerned. Number 4, to permit for profit any place to be used for the communication of the work. Number 5, to make infringing copies for sale or hire, or to sell or let for hire by way of trade, displays, or to offer for sale or hire. So these are the number 6, to distribute either for the purpose of trade or to such an extent as to what prejudicially the owner of the copyright. Number 7, to exhibit in public by way of trade, to import into India any infringing copy. In case of sound recording is concerned, importation is nowadays not required. It can be sent through internet, but it has also certain exceptions. If the sound recording is played in residential premises exclusively meant for the residents, of course it falls under exceptions. There is no infringement of copyright. Then if the sound recording is played as part of the activities of non-profit making club, society, organization, educational institutions, or any other establishment for entertainment only, so that shall not be treated as a infringement of copyright. So remedies against infringement of copyright, we have already discussed that there are basically 3 types of remedies available in case of infringement of copyright. So these are the basic protections given by the Copyright Act of 1957. And we have also international protection also in case of infringement of copyright. So the protection or remedies in the form of civil, criminal, and administration. In case of civil remedies includes injunction, means the victim, means the owner can approach to the court, file a case against the infringer, and if there is an urgent needs or emergency case, that if the court is not restricted the infringer is going to making numbers of copies, large number of copies. So in that situations, the plaintiff or the owner of the copyright can request to the court for issuance of emergency order, restrict the infringer, stop production or reproduction, stop publication, stop commercial exploitations. Then finally, because the courts needs to decide whether there is infringement of copyright or not by appointing expert in certain circumstances. So in that situations, if the court is satisfied that there is an urgency to stop the publications and all that, the honorable court may pass an injunction and restrict the infringer. That is one kind of civil remedies. Next is damages. Damages is not a plural form of damage. Damages means compensation. Whatever the loss, financial loss caused to the owner, that can be claimed from the court, or account of profit, means the infringer by publishing the pirated copy, by infringement, if any profit earned by the infringer, that can be claimed by the true owner. Then delivery of infringing copies, whatever the copies already prepared, already made, or already under in process, everything needs to be delivered to the true owner. And damages for conversions. So in case of any conversion made, in case of any damages caused to the copyright property or the property in which copyright subsists, that also can be claimed by the owner from the court. Then in case of criminality is concerned, criminal remedies includes imprisonment of accused, imprisonment of accused or not less than for 6 months, but to the extent of as far as imprisonment is concerned, the period of imprisonment is concerned not less than for 6 months, but to the extent of 3 years. But in case of consecutive offense is concerned, then imprisonment shall be imposed for not less than 1 year, but to the extent of 3 years. There is a provisions of fine also not less than 50,000, but to the extent of 2 lakhs. But in case of consecutive offense or second offense, then fined not less than 1 lakh rupees, but to the extent of 2 lakh rupees. Then in case of imposition of punishment is concerned, it is always discretionary of the court to see that the infringement is fair enough or for commercial purpose or commercial exploitations. Then we have also administrative remedies. Administrative remedies consist of moving the register of copyright to ban the import of infringing copies into India and the delivery of the infringing copy confiscated to the owner of the copyright. But that is all about the registrar or registrar of the copyright has a right to restrict or to make suitable provisions, provide securities that no infringing copy shall be imported to India. But nowadays, through internet, there is no need to bring infringing copy in hard copy. It can be converted into a soft copy. Suppose one person get one book, it can be photograph can be taken. That can be also converted into words. Then that also can be sent through mail. So there is no need to bring a hard copy nowadays, but registrar has the power to restrict. So there are certain judicial responses we can discuss here. Only a few responses I bring to discuss here in case of protection of copyright is concerned. In the first case, Garware Plastics versus Telelink and others, the court held that showing the film over the cable TV was constitute video piracy. Nowadays, we have very limited numbers of cable TV connection. Otherwise, everybody has a digital TV. So I think by minimizing the cable TV, telecasting of different pirated movie also be reduced. So in case of Mishra Bandhu versus Sribaratlam Kushal, it was held that the laws of copyright do not protect ideas, but they dealt with the particular expression of ideas. We have also discussed. Then in Raj Video Vision versus Mohan Krishnan, the court held that the producer of a cinematograph film could be regarded as an author of the film for the purpose of Copyright Act. Means the producer of a cinema or the film or cinematograph film shall be treated as owner of the film, because in one film there are lots of copyright. We have already discussed that in case of music is concerned, in case of actor actress performance is concerned, in case of composer, in case of painter, in case of designer, lots of copyrights involved in a particular film. But in overall, the owner of the film is the producer of the film is. So in Super Cassette Industries versus Music Broadcast Private Limited, the court held that grant of a license shall not be given on payment of reasonable charges to the copyright owner. Of course, in case of license is concerned, it is actus vivos, which is called as act between two living persons. So it is not operated by law. Then definitely the compensation or the consideration should be there. In another case, Chancellor Masterson Scholars of the University of Oxford versus Blushing Publishing House, the court held that there is no infringement for guide prepared from copying text from the textbook for the assisting solution of students in solving the problems. We have already discussed this point also. Then in case of Hawkins Cookers Limited versus Meiji Cook Appliance, the court held that the defendant using a label for pressure cookers, which are similar to the registered trademark Hawkins of the plaintiff, which is protected under Section 55 of the Copyright 1957, hence the permanent injunction was granted. So there are excuse me. There are lots of artistic or creative work of the human being may fall under different categories. One copyright as well as certain things under trademark. If you go to the market on footpath, you will get the shoes, socks, or different cloth with the name or even the symbol of Adidas, Reebok, the well-known trademark, well-known or business. And I don't know, generally they pirated things, means in case of trademark is concerned, Lee, Reebok, Adidas, all are generally pirated, and their articles are easily available on roadside. But I don't think so anybody take cognizance so moto and take any actions against those who generally pirated such things. So I hope the participants understand basic things of infringement or violation of copyright and remedies and related rights. With these words and with these slides, I conclude here. I thank you, all the participants and organizers, for giving me an opportunity. I hope the participants may have certain queries or questions, then you can proceed accordingly.
Thank you so much, sir. It was indeed a wonderful session you had with us. We have some questions. We'll start with one. Collection information for primary or secondary source are under copyright? If yes, how can we protect? So this is the question from Dr. Jaina.
Can I repeat the question? Collection information from?
Yes, sir. I'll repeat it. Collection information for primary or secondary source are under copyright. If yes, how can we protect that? Please share your experience, sir.
So collected information from the primary sources and collected information from secondary sources. Then of course, in case of copyright in literary work is concerned, suppose we prepared a PhD thesis. So that is completely based on primary sources of data and secondary sources of data. Then after submission of PhD thesis, if the thesis is good, the university also allow for publication of that thesis in the form of books. So we accordingly published that thesis in the form of books, and we apply for copyright. So copyright subsists in case of books, copyright subsists in case of thesis, even though the information has been collected from different sources. And when the information collected from different sources, we recognized the author of those sources. And in case of primary is concerned, that is primary data I have collected, and that is I am the owner of that data, because that is either through interview, either through observation, or through any other modes. If primary data collected I have collected, then I am the owner of that data. And how it could be protected? When I published it, I should apply for a copyright. And registration of the copyright is also not compulsory. But if it is infringed, my copy has been violated or copied by the other, then definitely I can take actions against those persons who infringe my copyright.
Okay. Thank you so much, sir. Very well answered. Sir, we have one more question from the Dr. Pooja. Does format or quality of the work matters?
Sorry, madam.
Does format or quality of the work really matters?
In case of copyright is concerned, format, there is no format, number one. Because in case of cinematograph film, is there any format? No. Every cinematograph, every film can get the copyright, the benefit of the copyright. In case of artistic work, no. In case of literary work, no. In case of computer software, I don't think so. So in case of other copyright work is concerned, and who will decide, madam, quality? Because according to, if suppose one thinks I feel that it is very quality work, the other person may feel that that is very rubbish and useless work. Means quality doesn't have any standard form. So relating to the copyright is concerned, which is what is most important things, it should be original, it should be creative, because PhD thesis, outcome of the thesis is a creative work. Even though suppose one thesis is completely based on secondary sources of data, everything has been everything has been copied from different sources. Only introduction and conclusion chapter belongs to him, and only few recommendation, suggestion, and establishment of hypothesis or establishment of research questions maybe belongs to him. Otherwise, everything thesis completely based on secondary sources of data, everything would be copied from different sources. But he recognizing everybody and collecting information, systematically arranged, recognizing every author, then it's definitely hard work is there, creative work is there, so he will get the benefit of copyright. So as far as quality is concerned, there is no standard form to measure quality.
Thank you, sir. We do have one more question. For conducting quality research, it is difficult to follow the Copyright Act truly? If yes, so kindly share your views on this.
To conduct quality research, is there any? Sorry, to conduct a quality research?
Is it difficulty to follow the Copyrights Act?
No, no, madam. If anybody wants to do quality research, then he or she should not be afraid from copyright of the others, because he is doing quality research. It means he is not copied 1 book, 2 books, 3 books, or 5 books, isn't it? Means who needs to be afraid from plagiarism? Who is doing not quality work? Who is just copied from 5 numbers of books and mixed up and submit the thesis? He needs to afraid from the concept of plagiarism, and he needs to afraid from the concept of copyright protection of the others, because we can copy it from different books. We have to acknowledge the author. Number 2, in case of plagiarism and similarity index is concerned, if I copied more than 10% from a particular book, then it would be plagiarized. And nowadays only those theses allowed to submit which has less than 10% of plagiarism or similarity index. So it means in my thesis I have been copied numbers of sources, not from 1 or 2 books. So if I copied from numbers of sources, then definitely it will be a quality works, and I should not be afraid or even make effort or thinking or wasting time in case of plagiarism and copyright of the others is concerned. But as far as my work and my copyright is concerned, definitely it will be protected because I have done well. And as for me, it is one of the quality work. because there is no clear-cut definition and measure and scale for determine the quality of anybody's art.
Yes, sir.
I hope this is the answer for the questions. Yes, ma'am. Proceed.
Yes, sir. You answered well. We have got such good comments in the chat box. Everyone is saying such a wonderful session, such a informative session we had today. And we're really thankful to you, sir. Before we proceed further, we do have a such, in a family, we have to thank you. And for that, I would like to request Dr. Anshul just present a vote of thanks to you.
Anshul, sorry to interrupt you.
Yes,
I had actually one question. Can I ask, sir? A question?
Yes, ma'am.
I've been intently listening to your session, sir. It's I mean, such kind of FDPs are little technical also on, you'll agree, on copyrights and trademarks, and these are ethical issues, but we do know there are a lot of violations. Sir, I just wanted to, because there are a lot of scholars also who are attending this session, and as faculty also, there are a lot of participants. So my question is, a key takeaway, maybe like, you've been interacting for almost 1.5 hours. So lot of digital content. I mean, we know the World Wide Web is there with us since 1997, and there has been an unprecedented growth in digital technologies in terms of maybe the value or the intricacies and the extent of usage. Sorry for the mispronunciation. What do you want to actually give as a message to a ground level message to people who are going in for using a lot of digital content that is available? Because we just pick up anything and everything and on the media or on the World Wide Web, and we are just using, despite the fact that we know things, that these are violations. We do have a Copyright Act in place, but in nutshell, what are the small things one has to follow to see that one is not doing any infringement of copyright, and one is careful on handling the digital technology? So your take on it, sir.
Madam, absolutely, you are absolutely right, madam. Everywhere copyright violations we can see. Even in the concluding of my talk, I have given examples of Adidas. I don't know whether it is available in Himachal or not, but which was available, I have seen in Pune, Maharashtra, even in Assam, Arunachal, and other place. Just like if you want to buy one shoes of Reebok, which cost maybe starting price maybe nowadays more than 2,000 rupees. The same shoes with the trademark of Reebok is available on the roadside, cost maybe 500 and 600 rupees. So nobody care of it. The same trademark, because Reebok definitely they may have a trademark, and which is not even expired, or even though if it is expired, then anybody can be used. But as per my knowledge is concerned, everybody has a trademark, but which is misusing here and there very easily. So in case of nowadays online different website is concerned, what they are doing, lots of copyrights violations is going on. Everybody have a knowledge, but nobody taken the cognizance of that, because who will take the pain for the others? Of course, the owner should take the initiatives for the protection of their copyright. Just like I also told that in case of generally Hindi movie in India released on Friday, even on after finishing the first show of that movie available on different websites, pirated movie recorded in the cinema hall. So I know, even I have the copy, even my friends have the copy, and they see the movie from home, either mobile or laptop. But who will take care of those things? Definitely it is the loss of the producer, because producer is the owner of the copyright. So the producer is sitting in Bombay maximum. So who will taking care of that things, and who will take the pain of that things? So that is why for new generations, if we talk about the intellectual property and its infringement, there is no concrete solution. There is no concrete suggestion that if such type of steps has been taken, then it may be minimized. Then definitely the burden should be given to the government and government agencies, because the police, they have a knowledge, but they are not taking anything. If you complain, just like well-wisher of any particular producer, then police will ask you, then what is your interest? Why you come here? Why you take the pain? Means lots of, you have to face lots of questions. So the law and order situation, because it's a criminal offense, it is provided by the act, it's a criminal offense. So the government should take the initiatives for the protection of such type of things. And number two is awareness is concerned. Only not everybody, but only few people who are educated in this field, they have a knowledge, but in India, the 70% people belongs to rural. So they may not have the knowledge and experience in the field of intellectual property. Few days back, one survey conducted by Indian Law Institute, Delhi, they asking certain questions through Google Forms, and which may not be filled up by the people who have a background in the field of law. So means any other people. And for final result or outcome of that result, I found and I shocked that maximums, even educated people who doesn't have the knowledge regarding intellectual property nowadays. So madam, thank you so much for conducting faculty development program in a such important topic, that is intellectual property. It's a trend. If such type of event conducted by different organizations and institutions, then more awareness would come, more social activities will come out, and they will take the pain and initiatives with the help of the government. Then it may be minimized.
Yes, yes, I agree, sir. Thank you, thank you.
Thank you, ma'am.
Okay, thank you so much, sir. Now, I would like to request you, Dr. Anshul, to present a vote of thanks.
Before Anshul, ma'am, I would like to thank each and everybody for organizing faculty development program in a such beautiful subject and topic. And intellectual property nowadays very popular for every educational institutions, because of plagiarism is one of the phobia for research scholars. It is phobia for those who doesn't want to give the effort for preparation of thesis or research. Otherwise, it is not a phobia. It is very appreciable medium for checking your quality, at least little bit quality, testing your quality of your thesis. So before plagiarism, nobody can understand that how much they copied from how much sources, and they have any idea. But nowadays we can say that my plagiarism is only 2% or 3%, and at least I'm satisfied with my thesis. So intellectual property nowadays is very important topic, and everybody needs to, every organization, institution needs to organize such type of event. So once again, thank you so much, madam. Thank you.
So I think we have been bothering you every now and then, and you have been quite responsive about our queries and the needs we generated. So thank you so much for that. And for the this session obviously was a very insightful session, you know, starting from the very basics like defining and making us understand the copyright, And you have, wonderfully thrown light on various laws that are governing the copyright laws and how they have been being dealt in India. And I think it is much required for us all to, how the infringement of copyright is being done in various fields, maybe music, you mentioned about artistic work, literary work, cinematography, etc. And most importantly, how we as authors, we can act against these infringements. So further knowing about the judicial response in the copyright protection, is what I feel was much required, because that in a way will make us all informed. The themes that you have covered, these were so comprehensive, and on the other hand, simultaneously they were inclusive too, that I feel that the listeners must have developed a clear understanding of how exactly, copyrights are being violated and what all rights an author reserves, so that his rights and his things are being, well protected. So let me present you a formal, vote of thanks. So on the behalf of K.R. Mangalam University, I, Dr. Anshul Saluja, Assistant Professor here at K.R. Mangalam University School of Education, I take an opportunity to extend a hearty vote of thanks to all the dignitaries and guests present here for gracing today's session. A special thanks to you, sir, for enlightening us. And before that, I would also like to convey my deep regards and thanks to our Honorable Vice Chancellor, Sir, Professor Dubey, and Professor Tripathi, Pro VC ma'am, for giving us this opportunity to conduct this at FDP. So their incredible, leadership, it has always been a catalyst that inspired us to do our best. So I would also like to thank Professor Dr. Tanya Gupta, who has been the greatest support and guidance behind us, and continuously, pushing us, motivating us to do our best. And with a deep sense of appreciation, I would also like to, thank Dharamveer sir for his constant support for the technical, dealing with the technical platforms and everything, making this session run smoothly. I have been fortunate enough to be supported by a team of dedicated and motivated faculty members, Manju Kundu and Ms. Kanchan Khatreja, who have worked really, really very hard for this FDP and making them available every now and then. I do duly acknowledge their efforts and willingness to complete the task before their comfort zone, So most importantly, all the participants attending this session, please accept my sincere gratitude for participating in this session. Professor Jenna, you are not the least, you are the first one. I would also like to thank you also. I thank you everyone for being with us this afternoon, and it was really a greatest pleasure. Thank you so much.
Thank you, madam. Thank you.
Thank you, sir. Thank you so much, sir. Thank you.
Thank you, sir, and thank you, Tanya ma'am, Anshul ma'am, and Jana sir, and every participants who is so much supportive and always join on time. So thank you everyone. We are ending towards the session. Hope tomorrow we have a valedictory session and the last day of the FDP. And thank you for everything. Thank you so much.
Thank you. Namaskar, sir.
Thank you. Namaskar. Namaskar.
End all webinar all kar de.